Welcome back from lunch, and welcome to those of you who are just joining us for the first time. This is the second panel where we will be talking about state responses or potential state responses to the scaling back of voting rights, particularly the voting rights of political and racial minority groups. So we are first going to hear from Debo Edegbile, who's a partner at WilmerHale, former director counsel and acting president of the NAACP Legal Defense Fund, now LDF, and later senior counsel to the Senate Judiciary Committee. Mr. Edegbile is going to give us some background on the 15th Amendment, the Voting Rights Act, the demise of Section 5 of the VRA at the hands of a US Supreme Court opinion that is 9 years, 9 months, and 20 days old. Not that we're all counting. So I'll turn the time over to you, Debo.
Thanks so much, Doug. It's good to be here with you. I've really enjoyed this morning's panels and speeches. They set the table nicely for this panel. And thank you also for reminding me of what is perhaps the biggest career disappointment in my life, having had the ignominious experience of having argued the Shelby County case. And so much of what occurred 10 years ago is the fallout from what we tried to urge the court not to do as we defended the constitutionality of a core provision of the Voting Rights Act in that argument. But I think I like to start when we're talking about the Voting Rights Act and those cases, painting a little bit of a picture about why the Voting Rights Act matters. We've heard a little bit about it earlier today, and I think it's very important to root that statute in our history. And what it stands for is a moment when, for a time, the country tried to, in a more serious way, and we've heard many critiques of our system this morning, and they are apt. Democracy requires work that's iterative, and so we need to understand that. But the key thing about the Voting Rights Act is that it took seriously the concept of a minority inclusion principle in American democracy. And it was intended to respond to a long history of systematic exclusion of many people from democratic processes across the country. And we heard a little bit earlier about who matters in the system of democracy. There are lawyers, there are other folks. The Voting Rights Act is a statute that comes to us because of the contributions of lots of folks, including folks that had nothing except the shoes on their feet to march and to demand that the country do more and come a little bit closer to live up to the promise of equal protection of the law. As a civil rights lawyer, I think about the work of litigating voting cases as an effort to make the high promises of the Constitution a little bit more real. There's a gap between what we say and what we do. One of the themes running through today is that there's a gap between what we say we do and what we actually do. And the Equal Protection Clause is fancy and important language, but if it's not being experienced on the ground, there's a question about how real our democratic efforts are. And so I see the work of civil rights lawyers as being the work to narrow that gap between the promises, the high promises of the Constitution, and what too often are low practices. All of this came to bear in the Shelby County case because one of the core provisions in the Voting Rights Act responded to the pattern of the case-by-case method being inadequate to protect minority voters. Why was the case-by-case method inadequate, right? You have a plaintiff, they see something that they think is challengeable, they bring a case, they litigate it, they get a ruling, they may get an injunction from a court. And then what happened in the area of voting is that discrimination was so entrenched and adaptive in the area of voting in many parts of the country that the officials would find a way to circumvent the ruling of the court. They would find a way to achieve the discriminatory end through a new voting method or mechanism. And so bringing a case one by one could not stay ahead of the discriminators. And so the Section 5 preclearance provision, that part of the Voting Rights Act, which many of us have called the heart of the Voting Rights Act, it was designed to create a new framework in which the discriminators didn't begin on the 50-yard line in the fight for democracy. It essentially said, it shifted what the justices have called the burdens of time and inertia from the would-be discriminators to the people. And the way in which it did that is it said that no voting change could be made until such time as the Department of Justice or a federal court in Washington had a showing made that the voting change, all voting changes, not just laws of the state legislature, but even things like moving around polling places and changing some of the time, place, and manner aspects of elections, things that seem small but can have big effects on election day. None of those voting changes could happen until such time as an affirmative showing was made by the government officials that they didn't worsen the position of minority voters. And so that was a very powerful and unusual civil rights statute that was responding to a specific context. It was responding to that context of adaptive discrimination that happened intergenerationally. And the Supreme Court in the Shelby County case essentially looked at the statute. Every time that provision had been passed by Congress, it was passed with a temporal element. And the Supreme Court each time had a case that challenged the constitutionality of the provision, in part because it was unusual, but also because it was so effective. There were jurisdictions that didn't like it because it required them to show their homework and prove that they were not discriminating. It took as a baseline that in this area there has been too much discrimination and that the underlying right is so important that we need to do something to interrupt it. And so there were challenges decade after decade that went to the Supreme Court, and there was a line of cases that said that it was constitutional. In Shelby County, the court sort of framed it at a time that we had the first African-American president as being too distant in time to when we had the intense discrimination of the 1960s, and they framed the statute as if it was archaic, that the particular jurisdictions that were subjected to it, because it had a geographic limitation as well as a temporal limitation. Most federal statutes apply nationwide. This was targeted at some of the states and jurisdictions that had the greatest histories of discrimination. And the court focused on these elements to say that it was a time to reconsider the constitutionality of the provision at that moment. And what they did was they essentially focused on the geographic piece, and they said that, in effect, in so many words, these jurisdictions are being unfairly put in the penalty box, and we can no longer justify the particular set of jurisdictions that are being subjected to the pre-clearance provision, where you have to come forward and get something pre-approved before it can take effect. We're not doing that anymore because you've unfairly targeted Congress. You, by a 98-0 vote in the Senate, have unfairly targeted these jurisdictions, even though there was a 15,000-page record that Congress had assembled that was showing that there had been progress. It acknowledged the progress from 1965, but it showed that there was still a lot of discrimination, and equally, of equal importance, it showed that the Voting Rights Act itself and the pre-clearance provision had been effective at turning away some of the attempts to worsen the position of minority voters. And so what happened was, on the day of the ruling, jurisdictions that had earlier provisions that were rejected under the pre-clearance provision, they enacted those things on the day of the ruling. And what we have seen on the other side is an effort to put many of these provisions in place, these laws that worsen the position of minority voters and erode the minority protection principle that the Voting Rights Act stood for. All of that is horrible, and we're going to talk a lot about that today. But as importantly as we think about today, and this panel in particular, that case had a signaling effect that the Supreme Court and perhaps the federal government were going to be in retreat from what had been a minority inclusion principle in the American democracy that had been forged through very careful and difficult advocacy and a lot of discrimination, and in some cases, people that laid down their lives in service of trying to open up the American democracy. And the court, with sitting and issuing an opinion from the bench in DC, said that we are going to reject this 15,000-page congressional record. We're going to interpose a new ruling that we heard this morning is disconnected to the precedent, announcing a new standard that a conservative judge said that the reason he didn't recognize the theory in the Shelby County case is because it appears nowhere in the Constitution. That was Richard Posner who said that on the occasion of the Shelby County decision. So we'll talk more about it, but I just wanted to set the table by saying that Shelby County is important because of what it did. It disabled an important protective statute, but it's as important because of what it represented. And we've seen that the onslaught of efforts to worsen the position of minority voters in part takes the signal of the high court that we're not standing watch in the same way, and that folks that would like to do these things have a greater path to do it, because if you flood the zone, there aren't enough lawyers to stop it in the case-by-case method. And I think that is how I see the legacy of that case.
Thank you so much. For those of you who have a program and would like to learn more about our speakers, I encourage you to read. They all have very impressive accomplishments. And you may also notice something unique about our next speaker, which is we have a lot of lawyers and law professors in the room. And then Moon Duchin is here as a mathematician. And you may wonder, why is a mathematician joining us to talk about voting rights? But Professor Duchin teaches math at Tufts, also does a lot of other really interesting work applying concepts of mathematics to redistricting, runs a redistricting lab, and is an expert witness in redistricting cases around the country. And so Professor Duchin is going to help us understand the mechanics of redistricting and the way the Supreme Court might undervalue the voting rights of minority populations in a current Supreme Court case that may come down any second. So thank you.
Great, thank you so much. It's really a pleasure to be here. Just starting a timer for myself. All right, so we've heard about Section 5, and I want to talk a little bit about Section 2. And in particular, as Professor Spencer just mentioned, I've been doing a lot of work in the past year or two as an expert witness in redistricting cases. So in 7 states, let's see if I can, so Wisconsin, Pennsylvania, North Carolina, South Carolina, Alabama, Texas, and Georgia. And the case in Alabama, which was Merrill v. Milligan, is particularly consequential. That's how it looks now. So I want to talk a little bit about some of how a mathematician comes to be relevant, perhaps, to this, and some of the state of play. Okay. So warning, here comes the only math slide. All right, so I want to set the stage by thinking about what we do when we do redistricting. So we take a territory, a geographic territory, and we divide it up. And depending on where different kinds of voters live, that creates districts that are going to have different electoral consequences. So this is just a little kind of toy example to point out that how people are distributed over the territory matters for what's possible when you redistrict. So here I have some 6x6 grids, and in each of these I have club suit people, voters. And each of the pictures has 12. So 12 out of 36, a third. And they're oriented differently so that there's a lot of distribution in the blue grid. There are 2 clusters in the red grid. There's 1 cluster in the green grid, and then there's a kind of frontier arrangement in the orange grid. These are just different arrangements of people. And now you might ask, if you were club suits voters, and you're going to divide this up into 6 districts of 6 squares each, where would you like to live in order to get the best representation? That's the question. Okay, so well, here's an answer to this. There are millions of ways to district this. I think the number is 150 million and some. And if you make them all equally likely, if you draw any districting plan with equal probability, this is what happens. So it's pretty interesting, I think. So I'm looking at the number of seats in which clubs have a majority. And because the seats have 6 squares each, it's possible to get half. That's why there are halves in here. Okay, so you really don't want to be like the blue club suits, because then your expected value, that's what that E is, you expect to get a half a seat. Whereas you have a third of the votes, and proportionality would give you 2 seats out of 6. Only a half a seat is the expected outcome if you're organized this way. In 2 clusters, it's much stronger prospects for representation, about 1.7 seats. In 1 cluster, it's nearly 2 seats, just about at proportionality. That's the expectation. Does everyone understand how these pictures work? Okay. And finally, that orange configuration actually gets a little bit past proportionality, 2.16. I'll mention, by the way, that a typical arrangement of 12 voters would only give about 1 seat, would fall far short of proportionality. So actually these clustered arrangements are pretty good in the sense that it's possible to get more representation. And I'll tell you that we did a computational search, and I can tell you that the orange configuration, you might be like, where did that come from? That's the best of all. It turns out, just as an empirical matter, we studied all the possible ways to place the voters. Orange is the best in terms of representational prospects. Okay, so this is if every districting plan is made equally likely. How about if you favor the ones that are, instead of long and spindly, that are plump and compact? Well, then things change and you get a somewhat different, not enormously different, but somewhat different picture. And so the whole point of this slide is to set the stage by saying that what you're able to do when you divide up a place into chunks that are going to do voting depends a lot on residential patterns, on patterns of segregation, on where people live, on how they're arranged, and on the kinds of districts that you draw, right? Okay, so that's the stage setting. Now let's look at some maps. So let's look at these maps. So here we are in Alabama, and it's a geologic map on the left, and on the right is what's called in geography a choropleth. That just means that the precincts are shaded by the percentage of, in this case, Black voting age population. Okay, so why do these pictures look so strikingly similar? It's the so-called Black Belt of Alabama, which has soil that's very rich, where many plantations were located in slavery and post-slavery times. And as a result, there's a lasting legacy of more rural, more agricultural, more heavily Black population, more economically depressed. So this is called the Black Belt of Alabama. How did the state of Alabama draw its congressional districts? This is how. And so what you see when you look at this is one district that looks what we'd call packed. It has very high concentrations of Black voters, and that's Terry Sewell's district. And then the rest, you see what looks like what is called cracking, where populations are split so as to be spread over multiple districts and reduce the potential for voting power. So this is the congressional plan that was challenged in Milligan. Okay, so what happened is that the different plaintiffs groups had experts, and I served as, and am serving still, this case is ongoing, as the Jingles 1 expert for LDF. And so these are the demonstrative plans that I drew for this case. Bill Cooper was another plaintiff's expert and drew, I think, 7 more, 11 more. There are a lot of demonstration plans on the record. Okay, so these are for what's called the Jingles prong that's used as a threshold condition to advance a VRA case. And what does Jingles say? It says that you have to show that the minority population, in this case, Black Alabamians, is sufficiently numerous and geographically compact to constitute the majority in a single member district. What that means has been kind of up for grabs over time, but in Bartlett v. Strickland, it was clarified that this means 50% plus 1 people. So you need to draw districts, in this case, an additional district with 50% plus 1 composition of Black Alabamians. Okay, and so let's compare, just going back to the last slide. This is the Black Belt, and it's possible to draw a Black Belt district, and that's what you see here in these 4 plans. Notable about these plans, they're overall more compact than the state. They cut fewer counties, or equal or fewer counties, in some cases fewer counties than the state. And so if you sort of look down the traditional districting principles, these plans are highly respective of the kind of canon of traditional redistricting principles. Okay, so what happened, briefly, so let me stay on this and say what happened, is that a 3-judge panel unanimously found in the preliminary injunction hearing that plaintiffs had a very high likelihood of succeeding on the merits, had sort of checked all the boxes, including this one, and that the map of the state was found to be discriminatory and had to be replaced. But the state had a motion to the Supreme Court to stay, and the Supreme Court stayed the ruling and heard the case in an October oral argument, and we're waiting on a decision in this case. Okay, so what was being asked for? Well, actually, it's a little unclear, and it's been a bit of a moving target. Alabama asked for many things, and those things moved around over time. But one thing is, well, let's eliminate the Voting Rights Act entirely. Another is to eliminate a private right of action. But a third is one that I find particularly relevant to my work, which is to impose a new interpretation that minorities are only entitled to as much representation as they would get by a blind draw. So if you were to close your eyes to race, if we can imagine such a thing, and draw districts at random, however many districts you'd get for a minority group by a process like that, that's the benchmark now. And so in other words, you'd need to show that those demonstration maps, which as the law stands today only have to furnish examples, now have to be typical of a blind draw. Okay, so it's the kind of appeal of all things race blind and maybe the potential that computers can deliver on this race blind kind of dream, right? Okay, so, but what we saw on the first slide, the trigger warning DeMath slide, was that depends very much on patterns of residential location, and that in fact you need a pretty high degree of clustering of a population, AKA segregation, in order to get a shot at proportional representation, right? Okay, so what you see here on the right is just such a blind process that's walking through the state of, in this case, Pennsylvania, and sort of randomizing districts as you go. And so this is the ask to sort of, one of the asks to pin the representational baseline to what you'd get blind. Okay, so I'll just close by saying this kind of reasoning would have all kinds of consequences. So this would tell us, for instance, that if we were to apply this logic to partisan redistricting, that Republicans deserve representation in Maryland, but not in Massachusetts. So what I'm showing you here is actual real precinct level red-blue plots of a 34% Republican election in Maryland and a 32% Republican election in Massachusetts. And so what's going on is that you have a real urban-rural divide in Maryland, right, which is, I think, apparent in the picture. But in Massachusetts, my home state, as I like to say, it's about a third Republican statewide, and in every county, and in every town, and in every precinct, and probably in every household, right? And so it doesn't matter how you redistrict. If every atom has a Democratic majority, you cannot make a Republican district, right? And so certainly a blind draw isn't going to give you Republican districts in Massachusetts. However, this is not where the court is going with this. As we saw in Rucho, this idea that the blind draw can tell you something about a baseline is now not to be used for party, but only to be used for race. And this leaves us in a kind of suspended state of affairs until we wait and hear how things come down in Milligan. Okay, thank you.
Thank you. You don't have to say it out loud, but like thinking about the implications of that for racial minority voting is kind of dire. So thank you for bringing that to our attention.
I'm sure we can discuss it.
We will discuss it more. Yes. All right. We'll finally hear from Professor Ruth Greenwood. I'm so sorry. Who's visiting us as the director of the election law clinic at Harvard, an election law professor there. And I, just as a personal matter, I want to say, because I see some of my students out there in my class, one of the things I really harp on is how good lawyers can win cases and bad lawyers can lose cases, regardless of what the law is. And Ruth is by far the best lawyer that I've ever worked with. And I'm really thrilled that she's here to talk to us. And that if you ever are looking for examples of good lawyering or good brief writing, you should go to the Harvard Election Law Clinic and find their materials and briefs and look at them, because they're very, very good examples of good lawyering. And Ruth's going to educate us, I think more hopefully, we'll see, about some of the measures that states are taking in the face of, the signal the bat signal that was sent out in Shelby County and all of the responses to that, this potential scaling back of minority voting rights by adopting this race-blind idea that could lead to a decimation of minority voting rights, and if there's space for states to step in and how they're doing it. So I'll turn the time over to Ruth. Thank you.
Thank you, Doug. I will say that I become a much better lawyer when I have an excellent expert on my side. Doug was my expert witness in a case where we won the first ever tri-coalition claim on behalf of the Black, Latino, and Asian communities in Virginia Beach. So that was due to his presentation of evidence. Okay, so I realize that we are in a hostile world in many ways, but there is still hope. So you can go, I like to think of the ways to go about change as a lawyer, right? There's community organizing, but as a lawyer, you can do federal cases. I tried that and lost in Rucho, right? Let's change the whole country and get rid of partisan gerrymandering. You can do federal legislation. So most of us here and many, many people around the country were involved in drafting the For the People Act and the John Lewis Voting Rights Amendment Act, which eventually became the Freedom to Vote Act. And that didn't get passed. You can also do state cases, but you can only do state cases if there are good state constitutions or state laws. So I have turned my attention to the states. To the extent that Milligan doesn't become a complete disaster, I will keep trying to bring, federal Section 2 cases to protect minorities that deserve protection. But as Moon pointed out, not all minorities are considered to be deserving of protection in the way the current Voting Rights Act is interpreted. But I am also trying to make changes to state laws and on the partisan gerrymandering context, changes to state constitutions through ballot initiatives so that there are still protections out there, even when hope is lost with the Supreme Court, as it may well be for a generation. So back in 2001, California very cleverly adopted a Voting Rights Act. Why did they do this? Well, Moon mentioned to you the Jingles test. So I thought I will briefly have a little moment of black letter election law. So the Voting Rights Act. Now, what Debo talked about with Section 5, I agree. That is the heart of the Voting Rights Act. That is the actual way that you would gain protections for people. Section 2 of the Voting Rights Act essentially writes out the 15th Amendment, and that's the one case at a time, right? Okay, if we don't have this underlying Section 5 protection, we can go, case by case by case and try to make changes to the most egregious circumstances. It became clear by 1982 that the way it was being interpreted wasn't allowing for the Section 2, I'm just going to call it Section 2 of the Voting Rights Act, to be used really for purely results-based discrimination. It's hard sometimes to go back to the documents where they decided to have an at-large election and prove that it was intentional discrimination, although one might think not that hard. But what Congress did in 1982, right? So we've got a Republican president, there are plenty of Republicans in Congress, and they passed an amendment that essentially adopts what's called a results test. And so it says that you can't, deny or abridge the right to vote on account of race or color, but if it would have the result of preventing communities of color from electing candidates of their choice, essentially. And that was interpreted by the Supreme Court in this test, Jingles, in 1986. That's the name of the case, Thornburg v. Jingles. So the first part, Jingles 1, that's what Merrill v. Milligan is all about. So at the time they said there needs to be a sufficiently large and geographically compact minority community to constitute a majority in a single member district. Now we get into the question, well, 2009, the question was, does majority mean exactly 50%, or do we just mean, an effective majority, as in people of color can elect their candidate? Thank you, Justice Kennedy, for being like, well, let's just make it exactly 50, which I think is really stupid, but that's that. Now they're like, oh, no, you can't even intend to draw a 50% district. You have to accidentally stumble upon one. That's this race-blind baseline that they're going at with Milligan. So Jingles 1. Jingles 2 and 3, I think, made a little more sense. You need the minority group to be politically cohesive. You want to say this is a community that votes together, and if we find a violation, we can have a remedy, right? We can put together this community together in voting and be able to elect candidates of choice of that community. And you also need to show what I call a lack of electoral success, right? So you need to show that the majority votes as a block. So you want it to be that, let's just use black and white. Black voters vote for one set of candidates, white voters vote for a different set of candidates, and the set of candidates that white voters vote for tend to defeat all of the candidates that the black voters want. Not every time, it doesn't have to be, complete exclusion. So for example, if you had a President Obama elected, that wouldn't suggest that the country is post-racial, right? Anyway, so this is the Jingles test. What California very cleverly did in 2001 was to get rid of Jingles 1. They were like, well, why do you need to have a segregated minority? Now, at the time, we hadn't actually seen as much decrease in residential segregation as we have seen now. I spent many years in Chicago, and if you say to people in Chicago, like, oh, residential segregation's decreasing, they're like, no, it's not. But in places out here, Colorado, Arizona, California, you do see that there is less residential segregation. The idea, I think, maybe when this court decision was based on a law review article, and I think there was some hope that it would sort of be a way station. So we would get to the point, or I think actually Justice Jackson referred to it as a sort of a self-liquidating clause, that when we no longer had all of this residential segregation, maybe we wouldn't have racially polarized voting. You know, we would have sort of contact theory, people living amongst each other, and it wouldn't be such a salient division in terms of voting. Unfortunately, though we have seen residential segregation decreasing, we still see, you know, sky-high polarization by race in terms of voting. So in California, where they said, well, we're not going to privilege segregated minorities. In fact, disparate minorities should be entitled to protections as well. So you don't have to prove Jingles won. So that was the first and main part of what they did with the CVRA. At the time they did it, though, there was a lot of pushback from the municipal jurisdictions who were like, wait a second, we are all going to get sued under this new, call it CVRA. And so they put in a safe harbor provision, and they said, look, so long as you adopt districts, any sort of districts, dilutive or otherwise, you are safe under the CVRA. You know, it was a compromise that I believe had to, my understanding is it had to exist at the time. It's not great, but there could be changes. And then it was also, they set up a notice letter system. So they said you can send a notice letter and then engage in a dialogue and have essentially a settlement or have a community change voluntarily. That has been used in both good and bad ways, and we can talk about that. But it basically provides a much lower barrier to entry. You know, these Federal Voting Rights Act suits cost a couple of $100,000. You have to get fancy experts like Doug to fly across the country for you. You know, they take a long time, and in the meantime, elections are occurring and people are being disenfranchised. The great thing about the State Voting Rights Act was that you can take out some of the more evidence-heavy parts. So they also made the totality of the circumstance. There's another bit that they made a little bit easier. So you can make it a little bit more straightforward, a little less expensive, and so more people can be enfranchised. Now, then we move on to 2018 to 2022, Washington, then Oregon, then Virginia, then New York, all start passing state VRAs. Washington had had two main benefits over California. It said, we're not going to have this safe harbor thing, right? If you decide to adopt districts, but those districts dilute the vote of people of color, no safe harbor, you can still be sued. And then they also made it explicit that you could have remedies other than districts. So the best language that the people pushing for the act could get was, the court may order appropriate remedies, including but not limited to the imposition of districts, which means that when you send notice letters, as I did with the County of Yakima, we could send a notice letter and say, we want you to adopt a ranked choice voting system. In that case, the only claim that we believed we could make out in court was on behalf of the Latino community. And I can explain why the Native American community didn't have sufficient data. It didn't mean that it wasn't a problem for the Native American community, but it was a small enough community that there wasn't enough data to get into court. So we could make out a claim for the Latino community in Yakima. But from the people we were working with on the ground, the Latino community and the Native American community very much wanted to be put together in a district where together they could elect candidates of choice. And the best way for them to get there would have been through ranked choice voting. Through a series of various steps, that has not happened, but I still think that someday it might get there. Okay, now, we've had California, a little bit of a step. We've had Washington, a couple more steps. In New York, LDF gets involved. Thank you, LDF, for coming to the table. They're like, right, we are reshaping this whole VRA thing. So you can still challenge districts. You don't have to require racial segregation, no Jingles won. They introduce a democracy canon. All New York laws related to voting, not just VRA, everything, shall be construed liberally in favor of protecting the right of voters to have their ballots cast and counted. So the very first time this was used was actually in a recount on Long Island, where they were trying to determine, you know, the sort of Bush v. Gore, like, does this signature count? Does this match? And they were like, pro-voter canon. We will interpret all of these as liberally as we can to count as many votes as we can. Ensure that eligible voters are not impaired in registering to vote, ensuring that people of color are fully able to participate in the electoral process. Setting that out as a canon. That's the first state to do it. All of the states that I'll talk about that are now looking at these have adopted this, which is fabulous. Also in New York, They remove deference to the defendant in selecting remedies. One of the really frustrating things when you're litigating in federal court in any of the redistricting contexts is that as soon as you chuck out the plan that you've been suing over, the defendant, the jurisdiction, gets to just draw its own remedy. And like, you can try to argue against it and cut around the edges and get a bit kicked out. But in New York, they were like, why give deference to the jurisdiction? They drew the terrible thing in the first place. The plaintiffs have just as much of a say, and the judge gets to choose a remedy. And that doesn't just go for redistricting, it goes for any sort of voter suppression techniques. They also list out 16 possible remedies that they're not limited to. So you could adopt an alternate method of election. You could increase the size of the governing body. That gets around a very specific federal case. You could change the date of the election. There is very good political science evidence that voting in non-November off-year elections is hugely disproportionately affects Black and Latino voters' governance outcomes, right? Not just their ability to get representation, but also to get representation that then translates into policies that the community wants. So change the date of the election, add additional voting hours and days, right? All of these amazing things. The NYVRA was like, why are we just looking at redistricting? Let's add a cause to stop voter suppression. Partly this is in response to the Bronovich case, which you may have heard of, that just didn't make Section 2 impossible, just a little bit harder and a little bit harder and a little bit harder. And it's, we haven't seen a successful Section 2 case since then. Go to the states, right? You can adopt and set out exactly how you want your voter suppression statute to list. It also sets up a pre-clearance system, right? Just like Debo was talking about. And you don't have to run into congressional power questions. They're the states. They can adopt pre-clearance if they want, query racial classifications law, but we can talk about that. But so they set up a pre-clearance system for the places that have this history of discrimination with respect to voting. They now have to go to the Attorney General's office and get their practices pre-cleared before they become enacted. So then groups like mine don't have to go and sue constantly. The worst things, we can get the things that are just pretty bad as opposed to really bad. And then also gets into voter intimidation, deception, obstruction, all sorts of things that we've seen a lot more of in recent years. So the New York VRA has all of these things, and it's only, as I say, it's been cited one time, but no case has been filed under it, partly because it's unclear whether it's come into force yet or if it comes into force in August, which is a confusing thing. But anyway, it's going to come into force soon, and I expect to see many cases under it. In terms of future VRAs, they are currently being considered in Connecticut, New Jersey, and Maryland, and there's like a soft coalition in Michigan to get one as well. And I realize if you look at this map, like what's missing, the South. But we're still talking about 80 million people are currently covered by a state voting rights act. That's 24% of the country. If all of these other places from this cycle get adopted, that's 99 million people. That's 30% of the country. It's not nothing. There are still ways to get through at the state level. And the one thing that I know many of the people here who teach, I have students write about projects that they want. And all my students from all of the southern states are always writing about how they have a plan to get state voting rights acts in the South. And so one of them will break through, I am sure. That's it. Thank you.
Thank you, Ruth. All right. So as you can tell, if those of you who study election law or voting rights, a lot of this will be familiar to you. For the rest of you, this can be relatively opaque and complicated. We have constitutional provisions of equality in the 14th Amendment, of voting rights for racial minorities in the 15th Amendment. We have a federal statute, the Voting Rights Act, that's in flux and itself has multiple parts. A Section 5, which was talked about, a Section 2, under which you can bring different types of cases, and then state law. So there's a lot of moving pieces, and we have an opportunity to just engage in a discussion for a little bit. And I've tried to bring some questions in 3 different buckets. So I'm hoping to just pose some questions here about the Voting Rights Act and the demise of minority voting rights, and then a few questions about state responses and alternative responses, and then maybe a few questions about the legitimacy of courts involved in all of this. And I'll target some of these questions to 1 or 2 of you, but of course, everyone's free to answer and discuss and partially think about ways to unpack some of the things that we were talking about before. So I'll start very broad, and I'll ask Debo and Ruth, I think. Moon, you're welcome to jump in on this, but I was just thinking back to the 2020 election during the vice presidential debate, which was held in Salt Lake City, the University of Utah. And during that debate, Utah Senator Mike Lee sent out a tweet that said, "We're not a democracy." And then he continued in the tweet, the word democracy appears nowhere in the Constitution because our form of government is not a democracy. And so I'm just curious, I've heard arguments and efforts that we should just amend the Constitution to guarantee a right to vote. That would change all of this, because right now a right to vote is implied, or maybe it's a substantive due process thing, or if we just said it, that would fix this problem. Do you think it would move the needle at all to add a right to vote as an amendment in the US Constitution?
So I guess my view is that it could move the needle, and that having an additional provision, if it could be passed, creates a new possibility for additional heft and for reinterpretation of some of the potentially negative opinions that we've been talking about. But I'm also mindful that we have also been talking about a 15th Amendment from which the Voting Rights Act derives, and a period of 100 years where the amendment was there, and all of the Reconstruction amendments were intended to enfranchise the freed African slaves, and for 100 years they were dead letter in most of the country. And so there is attraction to having more clearly stated the values that animate our conception of democracy, and there is some value in that. But as I also said, we had interpretations of the Voting Rights Act, which had been in place for 50 or now 60 years, and then the court reinterpreted and broke with a line of its own cases, upholding the constitutionality. And so part of the complexity of this is, one of the themes running through today is that judges and justices are capable of viewing things through a particular prism, and adding layers of legal complexity and nuance, leaving things out of their rulings that are apparent and the driving forces of what's at issue. And so I think it would be a mistake to believe that a new amendment standing alone is a panacea that would make everything great. In the first instance, that amendment would be interpreted by the current Supreme Court of the United States, which, as I have suggested, has been on a retreating path of protection of democratic ideals, and that's a theme that we've heard today as well. So is it worth doing? It's probably worth doing. Is it easy to pass a constitutional amendment? Not so much. It's not even easy to pass a federal statute, as we've heard. So value, yes. Solution, standing alone, no.
I would just add to that, with respect to the tweets about the Constitution not including the word democracy. Sure, it does talk about a Republican form of government. There's a guarantee clause, and that had a certain meaning at the time of the framing, which was reasonably exclusionary. But the founders aren't just the people in like 1776 or 1790. The people who wrote the 13th, 14th, and 15th Amendments were the founders of those amendments, and the 19th Amendment and the 24th, right? All of the amendments that relate to the right to vote. There were times when this country did decide that it would be a democracy open to more and more people. And so to sort of say, hey, it's not in the original Constitution, I think belies the truth of all of the struggles that have happened till now. That said, though I am an optimist, I am still with Debo on, yeah, you could write anything in the Constitution today and John Roberts will find a way to make it worse.
And just picking up on a very important point that Ruth underscored about, when you set this frame, if you're an originalist, when is the originalist moment that matters, right? Like, those amendments were designed to reformulate the Constitution. Thurgood Marshall has given speeches in which he talks about that was a new constitutional order. Even Justice Rehnquist has authored opinions that says that those amendments, the Reconstruction amendments, look up his opinion in a case called Fitzpatrick against Bitzer, maybe? Sorry, what is it? Fitzger, okay. Rehnquist, writing an opinion in that court, in that case, said that the Reconstruction amendments were specifically designed to reduce the power of the states and reorder some of that power toward the federal government, right? And now what we're seeing here is, because the Supreme Court is in retreat and throwing up its hand, saying in some cases some things aren't justiciable, a legal word for we can't wade in, leave it to the states. The Supreme Court is in retreat. Chief Justice Rehnquist, a very conservative jurist, acknowledged what the purpose of those Reconstruction amendments were in that opinion, but this court is doing something different. And during the oral argument in the Harvard and UNC affirmative action cases, there was a very important moment during which Justice Kagan said, I haven't heard too much about originalism today. Why? Because the interpretation in that case is about the Reconstruction amendments and whether or not they had built into them some effort to provide a more equal footing for people who had previously been disenfranchised after the Civil War. And so she said, I haven't heard too much. There's a deafening silence today from my original, she didn't add that part, but that's what she was saying. All of a sudden, originalism has gone quiet in the court today. You know, why don't we discuss that Reconstruction period and what the Reconstruction Congress had in mind? And so all of this is just to say that there is a sense in which good lawyers are capable of framing arguments in lots of different ways and reading in or out of the frame things that support the decision that they're ultimately trying to get to. So again, I rest on my earlier claim, are more rights that support democracy better? In the abstract, yes. Does that take you all the way home? No. The students sitting in these seats are going to have to work on taking us home.
Fair enough. All right, Moon, you showed us a bunch of maps, and you had labeled them demonstrative maps. And to just clarify, these are maps that you show a court at the very beginning of a case to prove that it's possible a court could redress the harm as like a threshold question. If a state is, or a county or somebody's found liable, then they, as Ruth pointed out, they get to draw an actual remedial map. Right. And those things are different, or they can be different.
They have been.
And the reason that we're required to draw these maps originally is because of this jingles factors that's been brought up a couple of times. And I'm just curious, as somebody who's been a jingles expert, do you think the jingles factors are detracting from robust minority rights? If so, what would you do to change that barrier, that threshold to get your case before a judge?
Okay, a few reactions. So first, the jingles, the introduction of the jingles framework, I think, was enormously helpful for the usability of Section 2. In that, it creates what seemed and have seemed over time to be fairly bright line, checkbox kind of questions to advance to the sort of totality of the circumstances and to get into liability, right? And then, as you point out, the drawing of a remedial map happens later, happens after liability has been established. Then someone goes and tries to draw a remedial map, and remedial maps try to do different things, right? But for Jingles 1, the wording is, I looked this up just a moment ago, the minority group must be able to demonstrate that it is sufficiently large and geographically compact to constitute a majority in a single member district. So if you're me and you're a mathematician, right, must be able to demonstrate means you're asking for an existence proof. You're asking for a proof of possibility. You're asking to show that something is possible. Now, over time, the way that that's played out, the interpretation has a little bit evolved. So for example, nothing in the sentence that I just read says that the district itself has to be compact. But over time, that's how it's become interpreted. And so that's been kind of read into Jingles 1, right? The idea that not only does the minority group have to be compact in the way they're geographically distributed, but you need to be able to draw a whole plan with compact districts. And so in a way, there's been a ratcheting up of the burden on the demonstration map over time. What it has to do has just increased. And so certainly one of the possible outcomes here is just that the ratcheting continues. In the current Georgia litigation, the state has articulated a position that the Jingles demonstration map must also be the remedial map, must be suitable for a remedy, which as far as I understand is novel. And so, right, so this is a possible way that things can go is just that, again, without technically striking down the VRA, it can become next to impossible to use by creating burdens that are higher and higher. So whether it's this burden of typicality or whether it's just a burden of having to have a map that accomplishes 25 things all at once, those are possible ways that this can go. And I'll just mention one more thing while we're thinking about demonstration maps and their role, which is that the 50% line is a really interesting one. Presumably, the history of that is just that that's an easy proxy for
People who are bad at math.
right? Like, if we look at that, it sounds like an easy proxy. If you have perfect polarization, then you need 50% to be able to prevail. But of course, that makes all kinds of simplifying assumptions that aren't true, like equal turnout and equal eligibility and and no crossover, just all kinds of simplifying assumptions that aren't true. And so you're asking, let's rewrite jingles right here, live, let's do it, right? If we're gonna do that, the 50% line makes no sense. It makes no sense in the context of identifying a harm that is remediable, right? It was in a time when it might have been much more difficult to go straight to the question of opportunity and effectiveness. It might have been a ready proxy, but now it's just one more thing that you have to do as a map maker to get to 50% and to get to effectiveness and to get to compactness and to get to minimizing county splits and all the things all at the same time.
Can I just jump in with a tiny roundabout math?
Yes.
So that 50% line comes out of a case called Bartlett v. Strickland. And that was Justice Kennedy just being like, well, that seems like a good bright line, 50, nice round number. And when the advocates were getting ready to argue Merrill v. Milligan, one of the questions that I asked was like, hey, you're going to overrule Bartlett v. Strickland. It's kind of insane. And even though we all in the community agree that it's insane, this is not the court to ask to do that, because then you have to get into the minutiae of statistics and math. This having litigated Rousseau, where we went to the court and we were like, you don't need to be, was it sociological gobbledygook they called, all of this math and political science stuff? To have dealt with that for years and then have the current court be like, this race-blind baseline is fascinating to me. Let's simulate 10,000 different plans and grab the mean of the distribution. I was like, oh, really? Okay, so we do understand math. And it just takes me back to what Debo was saying, that it kind of doesn't matter whether there's a lot of math or a little math or no math. They know what they want to get to and they get there.
After you, Marie.
Oh, sure, I'll just be quick. But yes, to sort of build back on that, so the 50% line comes from the Roberts Court. But if you read the transcript from Milligan, what you'll see is that a lot of the pressure on the Jingles 1 experts was partly the question, weren't you thinking about race when you drew these maps, right? And the answer, well, you told me to go for 50%, like that's...
Yeah, can I jump in on that? Sorry, Deborah. So the other thing on that is, and a really easy way out for this court, which they 100% will not take, is Moon is not the government. She is a Jingles 1 expert. You know who's not allowed to use race too much when they draw districts? The government, right? Under the 14th Amendment. Moon can use race as much as she likes. In fact, she was told to use it by you guys on the court.
By you guys.
And then she used it. Like when I read through those briefs and I saw all her answers, I was like, perfect expert. That's exactly what she was asked to do. She answered the questions perfectly, and then it got completely used against them in the court later.
Yeah, it was really interesting because I said, well, 50% is non-negotiable. And then you read the transcripts and the briefs and they're like, expert admits that race was a non-negotiable consideration. So that's sort of how it played out. But so yes, I think a very simple thing we could do, very simple, is revisit 50%, because it's neither necessary nor sufficient for what we're after here, which is access to representation.
I was just going to add one way to sort of view some of this jurisprudence and in particular in the area of redistricting is to think about what is redistricting in the first place, right? Redistricting is slicing the pie for political purposes, political power purposes, right? You're deciding where you're making the slices in the pie. Now, what is in the pie? In the pie is the American history of segregation, of residential neighborhoods, of folks that are being closed off from opportunity, of ways that for a long time we cut the pie to make sure that no minority candidate could ever be elected in states, including Alabama, where Milligan comes from. The famous Alabama gerrymandering case comes from, that's where it comes from, right? And so it is a history of dividing pies in ways that have minimized the voices of minority communities and cut them out of the system. So where does the compactness ratchet come from? Where does that come from? That comes from a time in the 1990s round of redistricting where under the Voting Rights Act and with map drawers and the like, in many states, including in the Black Belt, for the first time since Reconstruction, districts were drawn that gave African American voters the opportunity to elect candidates of their choosing in so-called minority majority districts where there was high racially polarized voting. When there's high racially polarized voting, where whites won't cross over to support a Black candidate regardless of their qualification. You can sometimes see it in Democratic elections where Hillary might run a certain way and Obama's running a different way, both Democrats. So you can see that it's race that's the driver, and the experts and the mathematicians can run so-called regression analyses to prove this up, where race is such a factor. In some places, if you don't have a district of some concentration that's substantial, you can't negate that refusal to vote for a minority candidate. And so when this was done in the 1990s, we had the largest congressional Black caucus in recent memory. And then what happens? The Supreme Court announces a new species of claim. They say it's a new species of claim in a series of cases designed to attack what they call so-called racial gerrymanders. Now, remember, I said for decades, districts were being drawn to exclude Black people and Latinx people, Native American people, Asian American people from electing candidates of their choosing. As soon as we have Black power in Congress and we're electing a different cohort, the court devises an analytically distinct claim, in the words of the court, to combat the evil of race in redistricting. Apparently that happened beginning in 1990. And there
were white plaintiffs, you see, and they were complaining that they were put in districts where they felt like race was used too much in the drawing of the district.
That's what happens, and the court complains about how these districts look, that they're bizarrely shaped. And all of a sudden, we start to have this new idea of compactness because now the map makers have understood, applying the rules of the game, that you can empower disenfranchised communities. And once you do that and it sees results, then the court announces a new set of jurisprudence, additional rules, additional claims that are used to push back on the diversification of the American Congress. And what we are seeing in these cases are the downstream effects of these rulings that are now trying to raise questions in that way. I'm shocked that race is going on in redistricting, right? Shocked. And it's disingenuous in many respects. It has been the coin of the realm. And now we're saying we can use it in one way to partisan political advantage. There, have at it, and we won't look and won't see. This court is disempowered to speak to it. But if you're trying to give a voice to a long disenfranchised people, then we're going to look at it with a special laser focus and apply the highest levels of constitutional skepticism to anything you might try and do in that regard.
Shifting gears from redistricting for a minute, but staying in the same vein of the court kind of making up new rules when it seems to result in the restriction and protection of minority voting rights. Ruth, you had mentioned this case, Brnovich versus DNC in your talk, and I know that you're litigating a case here in Colorado maybe that's related. It's not a redistricting case, of course, because Brnovich talks about vote denial cases under Section 2. Could you just give us a little bit of information about how the court made up new stuff there, and then how it's like playing out in this case that you're bringing?
Yep. So the Supreme Court hadn't taken a Section 2 vote denial case ever. It had always taken these vote dilution cases along redistricting lines. And so it finally took this case out of Arizona, and there was some question as to, well, how do we apply no denial or abridgment in the context of a voter suppression law? In that case, there was some closing down of polling places, sort of moving people to further polling places away. This is sort of more election administration problems. And in that case, Alito just decided there's already 3 jingles factors, 7 and sort of 9 totality of the circumstances factors. And he's like, I think we need 5 guideposts. Now, the really great thing about it is, and I love to think that one of the liberals like helped to edit the line that said, this is not a test, because I've cited that in every brief. But he set out these guideposts. And one of the particularly egregious guideposts is that we should look at the law as it was in 1982, year I was born, the year that the VRA was amended. And if something was really common back then it was probably okay. And like, why do you make laws? To get rid of the stuff that's existing at the time, right? Otherwise, don't bother to make the law. So, I mean, there are a few things that are insane. The good thing is, as I say, they're guideposts. And so in all of the groups that have been briefing this, we're like, here's some other things, like look at them if you want, don't otherwise. Let's look at everything else. In terms of Colorado Springs, that's the town that we're suing, for what I talked about before, the timing of the elections, right? So having non-November elections in Colorado Springs, we think is causing representational and governance sort of dilution for the Latino community. And so I mean, we can say a lot of things about it, but we sued them under Section 2. It goes to trial early next year. We're finishing up discovery at the moment. But the city decided that they wanted to wait until the latest election just happened because they wanted to include those results. And like, what do we see in the most recent results? Like, hugely disparate turnout between white and Latino voters in a way that you wouldn't see in a November election. And like, it makes sense, right? You tend to, if you have a million things going on in your life, if you are not a sort of privileged white connected person who can turn out to every election, it's harder to get in for all of the elections. Places like California and Arizona have made statewide changes to the extent they can to change elections to be on cycle. And so there is really good evidence by this Professor Zoltan Hajnal, who's down in Southern California, and he can run all his regressions and differences stuff. Not that I think it's sociological gobbledygook, it's totally accurate, but no, he can run all of this stuff and basically show you that it has a massive change in terms of enfranchising communities of color. And so if we are able to win that case and hopefully not have it go to the Supreme Court, then we maybe could win in other places as well and help to enfranchise communities.
And your bottom line takeaway maybe is Brnovich is not as retrogressive as others have made it out to be?
No, I mean, it would be if anybody applied it seriously. But so far, we are litigating in circuits where we intend for it to be not applied seriously.
Okay. All right, I want to think a little bit about the state response. So this conference is about like the retraction of certain rights in federal courts and then state responses. And in particular, election law, I find interesting because there's so much in the Constitution that explicitly tells states what to do that I don't think is as prevalent in reproductive rights, which is our next panel. States get to determine who's eligible to vote. The state legislatures prescribe the method of selecting electors, electoral college. State legislatures used to select senators. State legislatures get to decide the time, manner, places of election. So there's this sense in which not only are states a possible response to this, but maybe some of this stuff should be happening there in the first instance. And my question is, what happens when the states themselves go bad? What happens when states roll back voting rights? What happens when a Supreme Court in Rucho says, go to your state, but then you look at your state and you live in Wisconsin and your governor is a Democrat because the state's presumably slightly blue, but your state legislature is a supermajority Republican, so you can't, there's a disconnect in politics, then what?
I'll just throw in one more example,
Yeah.
which is in Utah. In 2018, Utah was one of 5 states to put an independent redistricting commission to the voters. And all 5 passed it, including Utah, right? And so the voters wanted an independent commission to be empowered to draw the maps. But because of the way, every state has different mechanisms for, allowing voters to amend the Constitution. And in Utah, that wasn't possible. So it was just a law. And so the legislature went right back and downgraded the commission to an advisory commission. The commission met. I did some work helping to advise them. They drew a bunch of maps and the legislature said, great, threw them out and enacted others, right? So there are definitely big differences in how easy it is to address what's happening in the legislature through other democratic means.
Okay, well, can I give you a hopeful story from Wisconsin? So the plaintiffs, I worked with 40 plaintiffs there from early 2013. So in 2011, they had this massive gerrymander put in place, and they have essentially, Democrats have been essentially locked out. Wendy Sue Johnson she lives up in Eau Claire. She'd been on the local school board when her kids were in school before 2010, when the gerrymander went through and when they did all the union busting with Scott Walker and so on. After the lines were redrawn, they used to always get together with all the local school boards, with the local elected representative, the state assembly members, Republican and Democrat, and they'd be like, here are all the things that are going on in our school boards. Can you take this down to Madison, get us what we need? Great. 2011, they redraw the maps. 2012, we're not holding those meetings anymore. We don't care what you want. We're just doing Republican things in Madison. So she resigns from the school boards. Then she's like, okay, well, maybe I can make change. I'm going to join this suit. So we tried this suit, kicked down by the Supreme Court. Okay, I'm going to go and run for office. And so I'm going to jump in, even though I know it's totally gerrymandered. Maybe I can make a difference. I can go door to door. She loses. Finally, this year, she's getting out the vote for a new Supreme Court justice, and there is now a change in the Supreme Court. And so, yes, it's been, 12, 15 years of her life, but it seems as though there might be change. And along the way, each of those things were very small odds. And even now, there's a change in the court. I have no doubt there will be a change in the court again sometime soon. But I think that the example of somebody who, her little kids that used to be in school are like left college now. I just think you can't stop, right? Like, what are you going to do? Just sit around and be like, great, like we will just have no democracy, thanks. I think that there must be people, I guess in Colorado, you guys are great here because you have all these wonderful laws and that's fabulous, but you're surrounded by states where I'm sure that is not the case. I think that people keep trying to make change in their own way. And so if it's not at the state level, maybe it is that even though they won't listen to the school board, on your school board, you can still make a change. Or maybe you can get your city or your county to do something differently. Like who controls, the police in Ferguson, Missouri? It's like the local city council. It's not state governed. If you want to help to stop police brutality, maybe local government is your way out, not necessarily state or federal. So I just think you need to keep fighting.
This harkens back to Professor Shapiro's talk this morning, but my reading of the US Constitution is, to the extent that there was any foresight that states might fail, the founders included this guarantee clause that we're going to give states all this authority to create your government structure, and then we'll make sure that we guarantee that they do it the right way by creating a Republican form of government that's become non-justiciable. There was kind of this back and forth. Ruth posed this question, and I would love to hear your thoughts about this, Debo. Is there any hope of the guarantee clause at all in the future, or are we just left to activism or other elements for solving these problems?
Well, I guess I would root my answer in the previous discussion about whether or not we have hope for the states and how we think about it. And it's a tale of two stories, because there are some positive aspects. There is a sense in which states are capable of being laboratories of democracy that can have positive innovations that can sort of point the way in for other states and then ultimately for the country. That is possible. It's a possible path. What I like to say in the area of voting is that there are two ways to win elections. One is the mobilization path, getting more voters out, allowing people multiple channels to get people out to participate, having laws that try to reach out to voters, to have votes counted and encourage participation. And we've heard about all sorts of laws in that regard. And I call that democracy's high road, winning through addition. But there is an equally effective American tradition in our system, which is demobilization, imposing obstacles, identifying who your opponents, likely voters are, and putting barriers in their way. And I call that democracy's low road, and that's democracy through subtraction. They're two different paths, but both can be effective. And what we've had in our history is a move from Articles of Confederation, which we heard about this morning, which is essentially states do what you do, there's no organizing principle. And we found that that was unworkable. And so then we had a constitutional system and the federalism principles that we talk about. And then we had a civil war where some of the states seceded from the Union. And the Civil War is definitely about race, but it's also about the mass deprivation of rights, period. It's states that are refusing to acknowledge the rights of some of their citizens, people who weren't acknowledged as citizens in some measure, but certainly of their jurisdiction. And then the Reconstruction Amendments are a reordering of power toward the federal government, recognizing that the states can't be trusted. That's what the Reconstruction Amendments are, that we have to limit the power of the states because we are not sure they're going to protect the citizens within their jurisdiction. And that's what that Rehnquist quote was about, a conscious reordering toward the federal government. And the Solicitor General's Office of the United States was created in that Reconstruction period because they understood that they needed more uniformity in how the Reconstruction Amendments were going to be interpreted in courts, just as they rode circuit around to courts around the country, and that the Union needed more uniformity in how the federal Constitution was going to be interpreted. And so I say that there is a future in which the guarantee clause can play a greater role, but it's going to require a court who understands how important having a finger on the scale to not allow it to revert to the chaos of the Articles of Confederation is, and that there needs to be some bounding and parameter for the democracy to function.
Thank you. I'm thinking about both something that I saw in your slides, Ruth, about remedies in the Washington VRA, and something implicit in your slides, Moon, about residential segregation. And just when I think about potential remedies, maybe from a state on a very practical level, why do we still draw districts is a question that I have. And I know you've written about alternative voting systems, and maybe you can help us understand a little bit about ways that we could empower minority voting rights outside of the traditional context of packing and cracking and carving people by geography, but maybe ranking votes or aggregating votes or something like that, and how that could play as a potential remedy going forward.
Yes, right. So all this talk of districts has to make us ask, why districts? What are they for? What are they good for? What are they supposed to do for us? And I think there are a few kinds of answers that are compelling in different ways. One is certainly to get local interests recognized. So that we read about, in the Federalist Papers, about competing local jealousies making their way to Washington. But I also see that when I live near Lowell, Massachusetts, which recently had a challenge to the city council election system on behalf of a coalition of Latino and Asian voters, and then decided to change the system of election. It was a kind of citywide at-large system, which we broadly all understand to be the most racist possible mechanism we could choose. And so the question on the table was, should voters draw districts, should the city draw districts, or ranked choice was the other option. So single transferable vote, ranked choice. And the city decided to put to the voters the question to vote on how to vote. And not by multiple choice, so they didn't get to choose between districts and ranked choice, they got a yes or no on both. So you can see various ways this could turn out messy, right? And what ended up happening, and so I went to some town hall meetings to try to explain how ranked choice might work as a mechanism and to talk about the pros and cons of each. So before I tell you how it turns out, just to say, what were some of the things that people were talking about? That there's a port of entry immigrant community in Lowell called the Acre, which had never had representation on the city council. That a small affluent white community had controlled 6 of 9 seats for decades. And so these kinds of geographical distortions were very much on people's mind. Neighborhood representation. When Austin, Texas changed its system of city council voting, the grassroots group called itself Citizens for Neighborhood Representation, Citizens for Neighborhood. So there's this very powerful idea of this, competing local jealousies, I suppose. Anyway, by the way, Lowellians voted, and they voted for districts at 60%, and the support for ranked choice was 48%. So they narrowly missed a kind of approving both situation and went for districts for the first time in their history. So, but the second point about why districts comes from the 1960s, which is, you know, in the language of the VRA, right, and then later in the Jingles tests, we have this language to be the majority in a single member district, but the system being challenged need not be a districted system. So there's this idea that districts are going to be a good possible remedy, kind of very much, I think, present at that time. And part of that is because the VRA is very much conceived as having to do with Black voting power at a time of heavy segregation. That Gamillion v. Lightfoot case was one where it was possible to draw all the Black people out of Tuskegee just by changing the lines, right? The idea that districts are going to be an effective remedy is then premised on the fact that it will be possible to draw them in such a way that you can get voting power. Well, maybe there's reduced residential segregation today, but also it applies to more and different kinds of groups. And you tend to see less concentrated segregation for Latinos, for Asian plaintiffs. And so the sort of utility of single member districts as a remedy just depends very much on all kinds of things about the particular facts of the case. So briefly, there are many other ways you can vote, of course. And ranked choice voting, in particular, the multi-member kind, where you are trying to fill several seats and voters rank many candidates and then votes transfer. This turns out empirically, if you model it, to do a very good job at giving something like proportional representation without any line drawing at all. Okay, well, if you're in a big place, like if you're in California and you want to vote for Congress that way, well, 52 is too many. And so you have to draw zones and maybe vote multi-member in those zones. But there again, you can model it. This is the power of bringing data science in with the rest of the policy thinking and the legal thinking. And it turns out, and I have a new study out about this, I think it surprised even me, I'm a big believer in this method, but it surprised even me that how you draw the lines for multi-member districts matters enormously less than how you draw the lines for single-member districts. And that's because this, we can talk about this later if anyone's interested, please follow up. But the fact that votes transfer smooths the sharp edges in this kind of first past the post system that single member districts brings us. All to say, I see a lot of hope happening, not just at the state level, but at the sub-state level, at the local level, where, you know, Lowell voted and didn't go for ranked choice, but then, you know, East Point went for ranked choice and then took it away. And now Portland, Oregon has adopted ranked choice. You know, it has a lot of momentum around the country. And I got a chance to work with Ruth on this, looking at Yakima in Washington. And there are many, many places where there are prospects for looking at alternative systems as a way to deal with all the paradoxes, perhaps, in redistricting.
Excellent. All right, we have a few minutes. I have just a final question, but it's tailored a little bit to each of you, and it's just about judicial legitimacy and how we should be thinking about courts in this specific area. So I actually want to start back with you, Moon, and I'm just thinking about this sociological gobbledygook that was referred to by Ruth and is actually a direct quote from Chief Justice Roberts about how to count. Anyway, some of the science and evidence, metrics, methods of evaluating voting rights are pretty new. And I think in some cases, the science is even still in kind of peer review process, maybe among academics. And so I'm just thinking of someone from your perspective who's not a lawyer, but is a concerned citizen and somebody who's engaged with courts and judicial legitimacy among scientists, social scientists, real scientists. I'm saying this as two separate categories, not as a clarification. I'm just curious your impressions about working as an expert, and how do you think courts are getting at the truth in our adversarial system? We have this, you know, Debo mentioned like this case-by-case method. You have a plaintiff, you have a defendant, and then they argue, and somehow truth emerges from this adversarial process. You actually do real kind of discovery of truth in that way. Should we trust courts that they're getting at the right answers when they do this or not? Or you become more skeptical or hopeful?
Well, this makes me think of a certain all caps email I received from a certain well-known legal scholar around the time that I was working on an amicus brief for Rucho, the Common Cause, which was like, just don't talk too much about any differences of opinion because the science will be worked out in future litigation. That's a quote. And I was like, really? Is that how we do science? But, you know, of course, what I think is really important to say here is that truth-seeking looks different in different domains and is never perfect. You know, I sit on editorial boards of pure math journals, and I'm not sure we do a super great job of vetting each other's proofs and seeking the truth. You know, law review is largely done by wonderful students like many of you here. And that means that empirical work in law journals that faces a challenge in terms of its evaluation. And to your direct question, how does it look in courts? I thought when I started as an expert that it would be very difficult to convince a court of some of these kind of, you know, algorithmic redistricting methods and their validity and their relevance. And actually what I found is that if anything, in my limited experience, there's sort of, courts are maybe too credulous of a professor with a computer, right? And so I think there's something interesting going on where the different methods of truth-seeking in different domains really should be synergizing. And, you know, I'm optimistic, but one thing that it relies on is that the expert community continue to operate in good faith and work together to sort of refine our methods together. And even though the court system is by design adversarial, to try to minimize that in seeking good methods. And I actually see for on that level lots of encouraging science about the future, at least in this domain of cooperation. One thing we really have to do is find journals that cut across some of the different assumptions and canons and standards. And I think that will help enormously, and that's something that I'm interested in contributing to.
Thank you. So Ruth, you litigated Gill v. Whitford and Rucho from like nuts to bolts, starting at the very beginning, finding plaintiffs to the US Supreme Court.
I'm a big loser, that's right. Continue.
That was not where I was going with that. But I have been thinking about Hamilton and Federal 78 calls the judicial branch the least dangerous branch. Alexander Bickel writes about this in the 60s, says courts actually maximize their importance and their reach when they exercise passive virtues by not getting involved, by staying out. And I think maybe that some read John Roberts' opinion in Rucho is in that vein, where the passive virtues are a strategic choice the court uses to lead the country in dialogue, allow issues to percolate. And you know, as somebody who is right up in like the well of arguing these cases and seeing this, is this an appropriate way to think about what the court is doing in the voting rights space, is giving us space as a political institution to percolate and come up to solutions on our own? Or is this an abdication of a duty and responsibility they have that's outrageous? How should we view the court as an institution basically after these cases?
That is the most sympathetic way you could possibly look at what the court is doing in voting rights at the moment. No, I think it's a complete outrage. I think that the current Supreme Court, largely driven by Chief Justice Roberts, are very partisan in the way they are deciding cases. They know with respect to partisan gerrymandering that one side is doing better at the federal level, and they want that side to continue to be able to do better. And then when it comes to the sort of racial minorities, they think that racism is over. They really hate the idea of identifying anybody by race and doing anything to help anyone. And given that, I think that when we litigate in federal court, I recently won a racial gerrymandering claim. Like the sort of cool thing about LDF and others at the civil rights bar was to sort of reclaim racial gerrymandering and be like, okay, this is an idiotic cause of action. How about we do it with Black plaintiffs, right? And so in the last 10 years, a whole bunch of groups have used it to try to enfranchise Black communities and build power. And so the case that we recently won on a preliminary injunction was down in Jacksonville, and we redrew the map and the election happened. And rather than having 4 districts where communities of color were able to elect their candidates, there are now 5. Should we really bring that as a vote dilution claim? Yes, but the courts don't care about the Voting Rights Act. And so I will go into court with whichever tools they give me to enfranchise the communities that need enfranchising. And I don't expect good faith from them, but I just do my best to align interests such that we can get to where we need to go.
Okay, and relatedly, I'll say, Debo, like you have left LDF, but you're still working in the law.
Right.
And I teach an election law class, and by the end of the class, students can become very disheartened and wonder. I came to law school because I saw the law as a vehicle for social change, and maybe a vehicle for expanding rights, like political rights. And now I'm not so sure. Maybe this was the wrong choice. Now, you haven't left the profession to go and start social movements. Maybe you're doing that on the weekends, but I'm curious, like, what keeps you in this, like, fight? Even though you have very eloquently today made me very sad about the state of affairs, especially at the US Supreme Court.
Yeah. So here I'm reminded of my late great mentor, Leon Higginbotham. Leon Higginbotham was the person who created the opportunity for me to litigate my first Voting Rights Act cases in the 1990s round of redistricting, which means I was very close to litigating redistricting cases close to before Ruth was born. To just, for those of you who are trying to do that math, I figured I'd supply it for you. And we took a loss in one of the so-called racial gerrymandering cases, a case called Hayes v. Louisiana. And I was very disconcerted. I was sitting in the judge's office, and I was very disconcerted as a young lawyer about the loss. I thought that we had history on our side. Louisiana went 135 years or something like that from Reconstruction, 116 years from Reconstruction until the first Black member of Congress went back. And then our client, Cleo Fields, was the second African-American elected, and his district was challenged. And ultimately we lost. And as I had a long face, Judge Higginbotham was telling me to imagine what this space must have looked like after Plessy was decided and folks got to the work that brought us to Brown v. Board. And sort of hard for a young, bright-eyed, aspiring civil rights lawyer to think about the patience and stick-to-itiveness that justice requires. But it's something I've come to appreciate, having won some cases, and as we've discussed, having lost some big ones, that in a sense, the reason that it's so important to have these convenings at law schools, at places where the next generation can hear about what the fights look like and what the possibilities are and what the difficulties and very real challenges are, is because we're not just in a relay race for justice in America. We're in a marathon relay race. We're in a relay that is intergenerational and where you have to keep passing the baton to the next generation to take up the mantle. So some of what I do as the gray hairs come in more regularly is to speak to the junior lawyers about what some of the fights have looked like and how you steel yourself to show up in the morning and get back to work in the way that my late mentor, Judge Higginbotham, charged me on that day when I sat in his office with a particularly long face. Alexander Kaysar wrote the book, The Right to Vote. And there's a narrative in America that we move ever forward, and that every day is better than the last day. But what Kaysar showed very effectively in his book is that in American democracy, the pattern is not unidirectional progress. It's ebbs and flows. It's progress met by retrenchment and focused efforts to push back. It's a breakthrough of Barack Obama. It's the Shelby County case. And then it's a legislature that tries to look for each and every way that coalition of voters in North Carolina created an opportunity for a Black candidate for president to carry the state and expressly try and close off those areas. That is the reality of what we do in America. And the only way to meet it is not to yield to the goals of those who would try to win through subtraction. And that's what keeps me going.
Thank you. Can you join me in thanking all of our speakers for this great panel?